right to individual dignity, right to privacy and equal protection, constrain the state when it decides to provide some benefits to some couples, but to deny them to same-sex couples like our plaintiffs. How else state sovereignty can help? The state can refuse to implement federal laws. The state can't be commandeered into carrying out federal policies that Montanans don't like. Some examples here in Montana where we have Montanans refusing to carry out federal policies, the Real ID law that the federal government passed. In that instance, the federal government stated that if a Montanan, an Alabaman, a Californian wanted to use his or her state driver's license to board a plane or various other things, that ID would now have to meet extra requirements. It was a burden on the state that they then were going to have to change their driver's license. Montana said no. Now, in many instances, what this concept means is that the federal government can't use a stick. It can't force the state to implement the laws that are passed by Congress. It can still use a lot of carrots, and I think that will be discussed as we move on. But we've seen instances where Montanans have said that we don't want that carrot, and the federal government cannot force us to eat that carrot. But what state sovereignty can't do? State sovereignty is not magic pixie dust. We can't simply sprinkle it over federal laws that we don't like and suddenly render those federal laws invalid. While Montanans might not make something illegal in our state, we may not regulate it in our state, our authority to make those decisions in our state doesn't grant us the unilateral authority to make legal what the federal government has made illegal. For example, with medical marijuana laws, here in the state of Montana, it is legal until the court rules otherwise and upholds Senate Bill 423. But it is legal for some Montanans to be able to use medical marijuana. It is not a state crime. However, as we all know, it is definitely a federal crime. Federal law enforcement is enforcing those laws here in the state of Montana. Let's not conflate our love of wanting to be able to make determinations about state law, our love of our authority in regulating what is legal or not legal under Montana state law, with our ability to render federal laws legal or invalid. If we want to challenge federal laws, we still need to think beyond simply furthering a states' rights perspective. That's only going to get us so far. I am going to wrap it up with what I think is a fun example of an individual being able to use a federalism argument to further her individual liberties. In Pennsylvania, a woman named Carroll Bond found out that her best friend had been in a relationship with her husband and had gotten pregnant. Carroll decided that she was going to smear a caustic substance onto the door handle, the car door handle, and the mailbox of her best friend in the hopes of causing some harm to her. Now, Carroll knew that what she was doing was wrong. And I'm sure Carroll knew that what she was doing was probably violating state law. What Carroll did not know is that she was also violating federal law that was put in place to enact an international treaty regarding the use of chemical weapons. Carroll was prosecuted by the federal government. Carroll was convicted in a federal court of violating federal law. Carroll asked the U.S. Supreme Court, "Can I assert the 10th Amendment?" The state isn't riding in on a white horse for Carroll, but she has a right under the 10th Amendment to be able to argue that the U.S. government has overstepped its bounds. These are usually laws that are left to the states. Supreme Court last June agreed with Carroll unanimously that the 10th Amendment belongs to all of us. It's not just owned by the state. It belongs to all of us. So when we talk about what options do we have for challenging the federal government overstepping its bounds, Carroll found a way. She is going to be able to argue that the federal law regarding chemical weapons is too broad. We'll see where that goes. That's still to be discussed. It's been remanded back to a lower court, so still to be discussed.
What's the name of that case?
U.S. v. Bond. That case is U.S. v. Bond. It was heard by the U.S. Supreme